Thank you to everyone joining us. My name is Tessa Shevlin, and I am the Business Development Manager for Dunlap Bennett and Ludwig. DBL is a veteran-owned and operated firm. We have over 80 attorneys who are licensed to practice in over 40 states as well as abroad. Today, I'm very pleased to introduce you to David Ludwig and Thuan Tran. We're going to discuss intellectual property as it relates to board games today. It's going to be a really fun conversation, and I'm excited to get started. But before we do, would you each like to share a little bit about your background?
Sure thing. Yeah, I'm David Ludwig. I'm a partner with the firm. I've been practicing intellectual property law for over 15 years, mostly trademark and copyright disputes, a little bit of patent work, everything from licensing to domain names, all various aspects of IP law. And I teach adjunct at George Washington University Law School in the IP sector as well.
Wonderful. Thuan, would you like to share a little bit as well?
Sure. My name is Thuan Tran. I'm a Virginia Bar attorney, almost coming up on a year now. I graduated from Washington Lee School of Law. And during the course of law school, I spent a lot of time researching intellectual property, specifically as it relates to board games. At the time, I was co-authoring a law review article with my IP professor, and so I've looked very much into this. And since that time, I've authored a few blog articles regarding the subject because I feel that it's a very niche subject that a lot of people are in the hobby, but not necessarily know the legal background behind it. So I myself am a avid board gamer, and I think anybody who knows me knows that fact. But I also wanted to bring kind of a legal perspective to this subject as well.
Wonderful. So to get started, David, can you lay out the basic principles of patents, copyrights, and trademarks for us?
Sure thing. Yeah, and before we get started, I just want to let everybody know that the program is being recorded. So if you happen to, most of the questions will be submitted via chat, but if you happen to speak, you'll be consenting to us recording you on that question. And we're just going to talk about general concepts today. So we're not really giving any legal advice about any specific matter because everything is sort of in the weeds of the facts of different matters. We're just going to be talking hypothetical concepts a little bit, but hopefully answer some of your questions and give you some more background information. So yeah, the three basic pillars of IP are patents, trademarks, and copyrights. We also have trade secrets, which probably isn't going to come up in the board game context. Patents are basically any useful article, usually inventions, often mechanical or software inventions that are new and non-obvious. So you have to invent something new that's never been done before, and if so, you get a patent, which lasts for about 20 years. Again, patents, utility patents don't come up much in the board games, perhaps a little bit of design patents, but mostly what we're going to be talking about today is probably copyrights and trademarks. Copyrights protect any work of what we call authorship, which isn't like it sounds. It's not limited to books or poems, although it includes those things. It also includes works of the visual arts, painting, sculptures, and music, all of that kind of stuff, any sort of artwork. And then trademarks is a big piece of it too, which covers brands, any signifier, logo, or word that you use to represent your brand.
Wonderful. And for anyone watching that's unfamiliar with this process, can you give us some more information on costs and timeframes when it comes to a trademark or copyright filing?
Yeah, sure. So yeah, trademarks and copyrights are filed with the federal government. Both of the applications take about a year to process just because there's a pretty big backlog at the government. Trademarks is a little more involved. Those applications can cost anywhere from, I don't know, $1,500 to maybe $2,500, sometimes more if you have a lot of problems with the application. And it takes, like I said, about a year, give or take. Copyrights are a little bit cheaper. Usually you could get one of those filed for $500 to $700 per work. But again, it takes a while for the Copyright Office to practice or to process those applications.
Wonderful. So let's dive into game mechanics. Juan, I'll direct this question at you. Can game rules and game mechanics be protected legally?
Sure. So this is a pretty common question when it comes to the community because sometimes you have game designers who come out with a game, they have this specific unique idea and they want to put it out there and they want to develop it, but they're afraid that somebody is going to, steal their idea. So when you consider actual game rules and game mechanics, those in themselves, if you consider the actual idea of, let's say, for example, you're placing a figure into a certain space in order to get like a resource or something like that. The actual game rule or the game mechanic is not necessarily protectable when it comes to copyright and trademark and patents. Now, you can protect what you consider the idea in the form of the expression. The expression has to be kind of sufficiently distinguishable from the actual rules themselves, because when you're having game rules or like a rule book, or if you have, like artwork on the box, those things are copyrightable, but the rules themselves are not necessarily copyrightable or trademarked. Because you look in the community, there's a lot of different overlapping mechanics, right? There's worker placement, deck building, etc. And these are all processes that are incorporated into these games. So certain games will take one and combine it with another, and it creates this whole new game. And those things are not, strictly speaking, copyrightable, but the expressions are, the rule books themselves.
Thank you for helping to clarify that. Is there anything that you wanted to add to that, David?
No, I think that really covers it well. We did a case years ago involving a local or DC-based kickball club, an adult where adults would get together to socialize and play kickball and have some beers or whatever, and somebody copied verbatim their whole rule book, and that was a big part of the case. Was, okay, well, you can't copy verbatim the whole rule book, but we can't copyright the idea of running bases. We can't copyright the idea of kicking a ball and throwing it home, and so it's the difference between kind of the ideas and how you've actually written them down.
All right. When creating a board game to show BG companies to sell, how do you protect your idea and prevent it from being copied?
So this goes along kind of in line with what I was saying, where the actual process of designing a game, most of these folks who are designing these games, these are independent, designers and independent publishers who might want to go their own self-publishing route, or they might want to go to a larger publisher. And so when you have this idea in mind, you have, certain like artworks that you want to be like copyrighted, you have certain rule books that want to be copyrighted. And so when you go to these companies, like oftentimes they're basically paying to license your game. And that all kind of boils down into contract law, which I'll let David handle because he's more experienced with that. But it's a lot of back and forth that I would recommend, deal with an attorney in order to get your terms across, because there are certain clauses that dictate how it's the distribution fees or like royalties. When you have public play testing, for example, that's a certain thing that you got to keep in mind, because oftentimes you have designers going to game conventions or sort of break my game conventions where this is out in the public, this is being exposed to different people, and there's not necessarily a way to like prevent someone from necessarily plagiarizing you. But at the same time, what you see in the game community is that, there's certain social norms that people follow. Just like if you have, let's say, a stand-up comedian stealing a joke from somebody else, or a magician stealing a trick from somebody else, people notice, both the game designers and the players notice, and there's a certain informal repercussions that exist when that happens. But I'll let David take care of the contract portions.
Okay. Yeah, I mean, if somebody's pitching an idea to a big company, we always would recommend, if you can get it, that you have some kind of non-disclosure agreement or, secrecy agreement with respect to your invention. But the practical realities are that those big companies might not really want to sign that. So you can certainly ask, and that's one way to protect your idea, would be a non-disclosure agreement. But a lot of times the bigger industry players just won't even bother to talk to you, and you'll be lucky to kind of have to get the meeting in the first place. So you may just have to incur some risk. But you can certainly, protect your ideas under a non-disclosure agreement. If you want to, before you go to the pitch, go ahead and file your copyright and trademark applications and get your IP protection nailed down. That'll help them from, copying your game wholesale. But the challenge that we've got is that a lot of the mechanics are not protectable, as we said. So, they would be free to sort of reverse engineer your game, or, copy your concepts in general terms, but write their own rule book and stuff like that. And there's really not much we can do about that, except kind of the cultural norms that Thuan was talking about, where, if they get a reputation for being a game stealer, they're probably not going to be very popular in the industry.
Thanks, David. That's
Going
really
along
helpful.
with those lines, yeah, just jumping off of that a little bit, we literally had a situation happen, maybe I'd like to say it was like 5 or 6 years ago. There was a French game company that, a game designer essentially went to them and pitched this idea of, I think it was like an alien game or something. And, they ended up not accepting the idea, but they basically did what David said, where they copied the game like wholesale. They basically copied the rules, they just changed around a few things, and they released it. And just like I mentioned, these informal societal norms, like the community reacted very strongly to this. They noticed right away that it was a blatant ripoff. And I mean, I don't know if the designer is still in business, but they developed that reputation for being essentially a game stealer. And those things are pretty strong as well. So despite the fact that there aren't, strictly speaking, ways to protect like game mechanics and game rules, you can also rely on these informal norms as well. But obviously, contact an attorney when you do so.
That's always good advice. I want to shift gears a little bit. We've talked about pitching perhaps to a company, but I want to talk a little bit about home use or personal use. Could an individual recreate a game that is out of print for personal use?
Yeah, so regarding that, like a lot of times you see I actually personally see this a lot in the board game groups, where somebody has a game that they really want to, play on their own, or maybe they also want to use the game for maybe teaching at a school for educational purposes. The first thing that I usually would recommend is try to contact the actual designer themselves, or like the publisher, and like see if you can use it, because a lot of times these folks are like lurking in the comments, lurking in the groups, and if you just ask them outright, they are incredibly generous and gracious that you are thinking about their game, and that they want to see you keep playing it. So oftentimes, if you just ask them outright, just send them an email if you find their email or their contact information, they will let you do it. Now, if you can't take that route for whatever reason, there are certain things that you got to keep in mind. Like, number one, if you are straight up like recreating what could be copyrighted material. So if you have cards with certain artwork that might be copyrighted, or cards with certain terms on there that might be trademarked, that might be a thing, be careful about that. There's nothing really stopping you from, creating like little like maybe like you take playing cards, you write little things on them, and you say, hey, these are the cards that we're going to be using, and you're just recreating the mechanics themselves to play the game. Now that should be fine, because as I mentioned, the game mechanics themselves can't be necessarily protected in the same way. But you kind of go into dangerous territory when you're, let's say there's a board that resembles some kind of map or some kind of artwork, and you are wholesale creating that entire artwork. That part I would be a little bit skeptical on, but at the same time, if it's home use, it kind of boils down to enforcement. Like if you're just using it by yourself with your family, or even if you're in an educational setting where it's for a nonprofit educational purpose, that could potentially, fall under fair use. But, for personal use, I think it's generally fine. David, do you have anything to add?
Yeah, I think that's probably right. It's mostly an enforcement thing. If you're just playing something in your own backyard, or at the kitchen table, people wouldn't even really know that you've copied their game. But there is a lot of misconceptions about this out of print concept, where a lot of people think, oh, if somebody's not selling it, then it's automatically fair use, or that it's automatically public domain or whatever. And that's not the case. You can sit on copyrighted works. James Joyce, the author, is famous for this. He has a lot of personal letters and effects that people want to publish, and his estate is just like, no, we're going to exercise our copyright rights by not putting this out there, not sharing it with anyone, and they absolutely have a right to do that. So just because it's out of print doesn't mean somebody doesn't still have rights in it. The rights in any copyrighted artwork last crazy long. It's life of the author plus 95 years in most cases. So if I made a board game when I was 30 and I lived till 80, that copyright would last, 175 years. So just because it's a game from the 1920s, just because it's something like that, it could still be subject to rights. And so you'll want to be, for personal home use, I don't think there would be a problem. In worst case, you'd get a cease and desist asking you to stop if you were broadcasting your gaming session on YouTube or something. But if you start selling them, if you're going to go on Etsy and start putting stuff out there, recreating old vintage games, you definitely would want to get a license first, because there is risk in any kind of commercialization. And a lot of people will say, well, what about fair use? Thuan mentioned fair use and use in the educational context, which is legitimate. But what I always tell clients about fair use is it's an affirmative defense. So you have to get sued, pay me to take your case all the way to trial, and then you can win on fair use. But what happens in 90% of the cases, even if you have a great fair use argument, is the game company that has a lot of money can just basically squash you in legal fees, and you'll never get to the trial where fair use will be determined. They will just outspend you, and you'll go broke trying to prove that your use was a fair use. So it's not something that that we want to rely on right out of the gate, especially if we're doing something just for fun that has potential financial risk.
Awesome. And in that same vein, when we're talking about distributing content, what are the risks, Juan, for distributing homebrew content for an existing game? And for anyone that's watching that's not familiar with the term homebrew, can you give us a quick definition?
Yeah, sure. So I consider homebrew content anything that any individual user creates in either to, supplement the game or just sort of create their own adventure, so to speak. When you have role-playing games like D&D, a lot of times, I myself, when I play D&D, most of the stuff that we play is completely out of the imagination of the DM. It's just complete, they're creating their own story. And so you have homebrew content in that regard. And then you also, what I would consider homebrew as well, when you're kind of creating maybe your own pieces, your own accessories to the games. And so I would say that in those situations, depending on what you're recreating, you might want to look at the publisher / the game's fan content policy. So Wizards of the Coast, for example, has a very, very clear fan content policy for if you use their D&D property or their Magic the Gathering property. They generally say, hey, feel free to use our stuff. We love seeing it. However, refrain from using our trademark content, in order to say hey, this is stuff that we've already trademarked. We already have the IP rights to this. Just refrain from using it. Do it within the scope of this content policy. And so, to the extent possible, look up the fan content policy and see what you're allowed to do and what you're not allowed to do. But also, when you're, especially, I see a lot of this on Etsy, for example. They're creating game pieces and whatnot. Depending on what you're creating, you got to be careful about, number one, let's say 3D printing is a really big thing these days. Being careful about creating something that is too close to what might be a copyrighted character. A lot of times, if you have some sort of let's say fantasy module or something, and you have some character that's in the fantasy module that is very distinguishable, they have a certain name, they have certain characteristics, whatever. Depending on how in-depth that character is based on the story, that character themselves might be copyrightable, and you are essentially recreating that character in little miniature format. Or the CAD drawings that people use in order to create these characters from the 3D printers, those also might fall under copyright. And so that's the one end of it. And then the other end of it is, it kind of boils down to the trademark and the idea of, if you're distributing these goods and they are heavily associated with the game that you're trying to create, then the company might say, hey, you're distributing these goods and people think that you are basically an official seller of these goods, and that might put you into trademark territory where you're in trouble.
Yeah, that's good. Yeah, I think I agree with all of that. I think the nice thing about this industry that we're talking about is that it does have these norms that Thuan mentioned earlier, where it is a little more permissive. You know, technically in the eyes of copyright law, fan fiction is a derivative work that's infringing. Any sort of adaptation or changes could result in legal action, but you've got a community of players that work together to sort of embellish the games, and most of the time the content creators or the original game owners are okay with that because it makes people more involved and it makes the game more exciting. So if it's sort of sanctioned under their terms or policies, they'll be okay with it. But it's, even though it's technically a violation, just because it's good for business, it's good for the community, it's good for their reputation. You know, game creators generally don't get a great reputation by suing their own fans. So there's a lot of normative reasons why they would allow some of the homebrew content, but you just want to be careful not to directly step on their toes. If you're doing something that's directly competing, if they're selling a figurine of one character and you're selling an identical figurine that competes with their ability to sell, that is something that they might be upset about. I know Wizards of the Coast that Thuan mentioned, they're very protective of their trademarks, as he said, and they've initiated a lot of trademark proceedings. So, you know, but that's something that just, as long as you can stay away from those hot point issues, most of the time this homebrew content is kind of acceptable to the game companies.
I want to dive into modifications. So when we're discussing modifications for games such as reskins, unofficial expansions, or fan-made content, is there anything specific that either one of you would like to discuss when it comes to modifications?
So depending on what the modification is, and also naturally what you're using it for, it could fall under fair use. So if you have something that is like a transformative, the nature of it is transformative, and you're really just using it, you know, for yourself, then it could fall under fair use. But as David said, it's an affirmative defense, and you don't want to like go too crazy into that. And also just like, I saw this somewhat recently. It might have been maybe the last year. Somebody created an unofficial, I guess, like reskin of this game called Horrified, which is this cooperative game. It's based primarily around like the gothic monsters like Dracula and werewolf and whatnot. And they recreated the game essentially, but they used modern characters. So they used like, you know, Jason Voorhees, they used Freddy Krueger, they used Pennywise from It. And it was a beautiful reskin. It was like amazing. However, the difficulty there is they are quite literally using trademarked characters, you know, copyrighted characters, you know, Pennywise from It, you know, a perfect recreation. It looked beautiful, but if you get into a situation where you might be like distributing it, well, then the owners of these IPs might go after you and say, hey, you're using our IPs without licensing them. So, you know, either pay up or stop. And I think in this situation, it was for personal use. And so, you know, that's a different realm. But at the same time, if you're broadcasting that you're doing it, you got to be careful about making these reskins and making these modifications, because, you know, as part of the community, you know, sometimes we love to see it. But at the same time, everyone's always kind of chiming in and saying, hey, you got to be careful. And they're right about reusing these trademark names and like kind of portraying yourself as an official distributor of, you know, the published game.
Yeah, I think a lot of users don't realize how much IP licensing goes into those collaborations that you see. If you're playing Fortnite and you see, you know, Luke Skywalker or Iron Man pop up there, that's all licensed and paid for. Those aren't just, you know, users having fun with the skins. That's a huge lift for those big companies to cross-license that intellectual property. It's not just something that you can kind of throw together lightly. But yeah, those and the, you know, a lot of in the video game sector, we have a lot of issues with just different manipulations of IP. Or there was a famous case involving World of Warcraft where somebody didn't like the game's rule set, and they basically duplicated the entire game server and created a parallel World of Warcraft that other people could log into, and they created a different rule set, but with all the same characters, all the same backdrops and landscapes and everything. And of course, that didn't go well. They got that was the subject of a big lawsuit. But yeah, it's certainly, if you're doing anything, I think the general rule is, if you're doing anything that takes money out of the pocket of the game developers or uses third-party IP that's going to get the game developers in trouble, that's going to cause problems. Personal use is generally not as big of a deal. And then, yeah, you want to be really careful with the trademarks and any kind of representation that would send the signal to somebody that you're connected with, the official game owner, or that you somehow have their blessing in taking on this project. It's tough because when we talk about utility patent infringement, which we're not really talking about today, but that's like for technological inventions, the patent claims are very specific. Your invention patent states exactly what your rights are. And whatever the patent says, those are your rights. And then the only question is, does that apply to the alleged infringer? But when we talk about trademarks and copyrights, the rules are a lot more squishy. And a lot of people come in and they say, well, I couldn't have violated their copyright because I didn't literally copy every single word of their rule book. And we say, well, the test for copyright is not every single word must be copied. It's whether the two works are substantially similar. And so how do we determine what's substantially similar? That's sort of a more gray test. And similarly for any kind of trademark infringement, the test is whether a typical consumer would likely be confused. Well, that's not a very clear-cut test. Like anybody, reasonable minds could differ about whether somebody would likely be confused. And that ambiguity then causes problems where somebody, your modification or your use of it or your resale might be totally harmless, but someone could still assert their rights and say, oh, we don't think it's harmless, we don't agree, we think you've gone a little too far, and then assert their claims that way. So you want to sort of be on the lookout for that, especially in the commercial context. If you're going to be selling any of these products or offering them for sale, want to be really careful with that stuff and do some due diligence in terms of the content owner's policy, what the scope of their rights are, how you're using it, what the scope of your rights are, your fair use arguments, and kind of look at all that before you start putting something out into the marketplace.
Wonderful. I'd love to go ahead and open up the floor for any questions that our viewers might have. Please feel free to put those in the chat, and we will get to as many of them as we have time for. Is there anything, Thuan, that we didn't get to talk about that you wanted to make sure that we touched on, or do you feel like we covered everything you were hoping to discuss?
I think we've mostly covered everything. It's an interesting subject because I feel like, despite the fact that games have been obviously around for a long time, especially in the community, there's overlapping misunderstandings on how things work. So, for example, this is just a random example, but it's a common thing that sometimes people bring up. When you look at like Magic the Gathering, for example, they have this mechanic in the game that's called tapping, and you turn the card sideways, and it denotes that the card has been used. Because that Magic the Gathering is actually one of those rare games that actually achieved the patent. It was, I forgot what year it was, but it expired a few years ago. People think, and they associate the whole idea of Magic the Gathering being patented with the idea of tapping the card. The mechanic of tapping the card has been patented. And it's kind of an overlapping understanding where they think patenting is the same thing as trademark or the same thing as copyright or et cetera. Whereas that's not really the case. These are distinguishable categories, and certain things slot into certain categories, but not others. And board games and tabletop games in general, they represent just an overlap of these different types of IP laws and these IP schemes, where copyright might cover one thing, but then trademark covers this other thing. And the intent certainly behind this webinar was to sort of distinguish those things, explain them in a way that people understand, because I know there's a ton of misunderstanding, a ton of miscommunication, and I have to refrain from jumping in every now and then when I see those types of those questions come up, or if somebody just says something that's wildly incorrect. I'm just like, okay, well, I'm not going to say anything. I'm just going to move on with my life. But it's certainly like a growing field. I think the industry itself is a very interesting industry, which is obviously why I'm super into it. Yeah.
Thank you so much, Thuan. It looks like we've got someone typing, so I'm going to give them just a little bit longer to get their question in. Okay. We've got a question that says, what recent popular board game would you say has faced the largest amount of copyright/trademark infringement claims, and why? Is there a particular game that it comes to mind?
Infringement. I'm not sure about infringement. I feel like there are a lot of companies out there. Well, I don't want to say a lot of companies. There are certain companies that are very vocal about their enforcement. So, for example, we referenced Wizards of the Coast earlier, that they are avid about pursuing their IP right. And like, if there's somebody out there who might be infringing on their trademark or their copyright, they're very quick to send, cease and desist letters or communicate that, hey, we have these rights, we believe you're infringing them, please stop. So there are certain companies that have that kind of reputation. Certainly, if you look at the early days of D&D, like TSR was colloquially known as a very litigious company, and they didn't have a very good reputation because of that. But you also got to consider the flip side of the coin, where if you have rights in something, in some IP, and you are not asserting them, you could essentially be relinquishing them if you're not watching out. So I can't think of a specific game or a specific publisher that has been sued a lot. To be honest, I haven't really looked into it, but maybe the reverse side. There's certain ones that have certain reputations.
Thank you, Thuan. That's a really good answer. All right, we have a question. This is very detailed and specific. Let's say we're retro cloning a non-OSR RPG or board game. The game has a table with arbitrarily numbers following a vague non-formulatic pattern used for conflict resolution. Can that sort of table be presented in the clone, or must it be written fully from scratch using a different data design? So it sounds like this is a question regarding retro cloning.
That's interesting. Yeah, so generally, tables and forms are not sufficiently expressive to qualify for copyright protection. They might seek protection. They might say that the selection and arrangement of numbers was somehow creative and might be protectable. So perhaps you could rearrange the numbers. There's been quite a bit of litigation over numerical data in terms of copyright. The Kelly Blue Book, the popular car valuation tool, has been kind of at the forefront of that, saying that their numbers in terms of car values are proprietary, and other people have said, well, no, you can't copyright facts. I can't copyright, the fact that a car is worth $1,000, but they claim that they can. And this would probably track with that a little bit, where they would, if you can establish that the order and selection of the pattern of numbers is somehow proprietary or unique as opposed to just random, then maybe you could do that. But probably, to answer this individual's question, if you wanted to copy that game, you could just rearrange the numbers and probably get around any accusations that way, because the pattern, the table itself, is not protectable. So perhaps you could just shake it up a little bit.
As a follow-up to that, let's say a numeric table is presented in a game and it can be broken out into a mathematical formula. Can such a table be presented then in a clone product if it can be broken out into a mathematical formula?
That would probably, any kind of algorithm or math is not protectable, really, as just sort of facts or the laws of nature. You can't monopolize that. So I think if it was based on, and even if the table we were talking about in the last question, if the random scattering of numbers was actually some kind of algorithm or some sort of if they were all square roots of one another or whatever, those patterns are not protectable, and those numbers themselves are not protectable. So you'd probably be pretty safe in cloning that, I would think, because it's just math.
I hope that helps. If you need more detail on that too, please feel free to reach out to us. Next question, what would be one piece of advice you would give to a law student looking to work in the IP board game industry?
Well, given that I'm directly out of that, I'll go ahead and start with that. I think like this is one piece of advice that I give to quite literally everyone. This doesn't even need to necessarily be restricted to IP and board games, but it's just networking. It's talking to people, and I understand that that's a very general piece of advice. But to give more detail to that, just some background on how I even got started in the first place. When I was in law school and I had a property professor who, we were talking about like zoning ordinances, and I literally thought to myself, wow, this is weirdly familiar with this game called Suburbia that I play quite a bit. And I quite literally mentioned it to him after class, and he loved it. And he's like, oh, well, bring it in. I want to see it. And I said, sure. And so the next thing I brought it in, I showed it to him, and we were just talking about games. And, he offhandedly mentioned the idea that he was kind of contemplating writing this law review article on board games. And I immediately jumped on it and I said, I will 100% research for you. Like, I don't care like how long it takes, like I will be willing to do it. And that's kind of how we got started. And it was through that specific paper that I did, an enormous amount of research into not only the game industry itself, but also IP law. It's like a large basis of my intellectual property knowledge. And, it was through that professor, I met somebody else who, worked at Dunlap, and I communicated with David through him. And it was just kind of a snowball effect where I talked with one person, they connected me with somebody else, and it just continued on and on and on. And that's just kind of how you have to approach it. A lot of times, whether it's through email or like a phone call, or a lot of times LinkedIn is a big thing these days, I just reach out to people who publish interesting articles, or they have some sort of update that I'm very interested in learning about. And I quite literally just reach out to them and I say, hey, I saw your post regarding this. I'd be interested to learn more. Do you have time for a 20-minute phone call? When we were interviewing game designers for the IP and board games article, that's quite literally what I did. I reached out to different designers that I saw were in the area, people who had their contact info there, people with interesting backgrounds. I reached out to another board game lawyer, who I saw his work quite a bit in the forums, and I just reached out to them and I said, hey, I'd love to learn more about your industry and learn more about how you conduct your work. And I still talk to him to this day. I still talk to a lot of the folks to this day. And it's just a matter of, asserting yourself in that way. A lot of times I feel like we feel that we're bothering people by sending them emails to ask questions. But I don't know about you, David, but every time somebody asks me a question saying, I'd love to learn more about your background, I'm always very happy to share my background and how I got to where I am, because I feel like I'm paying it forward and helping somebody else get into the industry.
Yeah, no, practitioners love to talk about their work, especially if they're passionate about it. So don't be shy about reaching out for networking or informational interviews. And, in terms of the law student, I think you just want to, if you want to end up in the board game industry IP space, you can't really, the chances that you're going to get that dream job right out of law school are pretty slim. So I would say go wherever you can build the skill set that you would need for that industry. So it's mostly IP issues, licensing, disputes, stuff like that. So if you end up doing, IP in a different context, but you're still doing trademark disputes, then you'd have that relevant experience to then pivot to more of an in-house role or something in the future once you've kind of built your skill set up.
Wonderful. So to wrap things up, I've got one more question for you, David. For anyone that's listening that has IP legal needs, why would you recommend that they reach out to DBL specifically?
Well, we started when I joined the firm in 2007. We were exclusively IP. We were a boutique that only did IP work, and we've kind of maintained that core through the years. So we now offer a more wide breadth of services, but IP's always been kind of the heart and soul of the firm, and we've been, doing it for years. We're always one of the top 10 or 15 trademark filers every year. So we know this stuff. You'll want to get somebody that's got the experience and the specialty and doesn't just dabble, because it can just be a lot easier to get everything done. I can't tell you how many times I'll get into a negotiation with another lawyer that doesn't really understand IP. They're just sort of are in the case randomly, and it's just hard to get anything done because they can't have an intelligent conversation. So it's always better to have that experience, and I feel like we have it.
Wonderful. Well, thank you everybody so much for joining us today. And thank you again, David and Thuan, for your time. This was a really enjoyable conversation. I'll be following up with everyone by email too. So if you have additional questions, please feel free to reach out to me directly, or you can give our client services team a call. Thank you guys so much. Have a great day.
Thanks, everybody. See ya.